All right, welcome everybody to today's webinar. Today we are talking about predicting judicial decision making with machine learning, and we're focusing on something called worker classification. So worker classification comes up whenever you have somebody providing services for another individual or another business or another organization. And there's a question about whether those services are provided as the worker being a business for him or herself, or whether that worker is actually in the employment of the other party. So we're going to get into that. I am your host, Ben Alarie, and I'm the co-founder and CEO of a company called Blue Jay Legal, a company behind a product called Tax Foresight, which we'll talk about a little bit later. And Tax Foresight is co-branded software brought to you by both Blue Jay Legal and by Thomson Reuters. But we're going to get into that. Mostly our focus is going to be on worker classification. We're going to dive into an issue, look at how it comes up, look at a recent case, and really unpack that case and look at how you might use new AI tools to solve that kind of case in the future going forward. And this functionality is all available right now, and it's also the future. So before we get into it, I'm going to just talk a little bit about the context for these sorts of situations when you might get into it, try to contextualize where the software comes from, what it's all about, and basically introduce the idea of using these kinds of tools to answer legal questions, especially in tax, which we're going to get into and actually do a hands-on example with today. So let's just jump right into this. So this is the way that we think about the evolution of legal research tools at Blue Jay Legal. When I was a law student, now many years ago, we started off looking really at analog tools. The law library was largely hard copy materials. We did have some CD-ROM, so we did have some of the digital revolution penetrating the law school in the 90s when I was a student at the law school at the University of Toronto, but very much it was an analog-based legal research world. Now, of course, virtually every law library, every law firm, every accounting firm, all the government agencies have basically made the transition over to digital legal research tools. And there are lots of advantages associated with digital legal research tools. For one thing, you don't have to worry that somebody else has taken the book out that you want to look at. All the materials are available to every user of the system all at once, so you don't have to worry about there being just one copy of a particular resource. Basically, everyone can use it all the time. And also, you can search very quickly. Long gone are the days of card catalogs and looking at manual indices of materials. You can do keyword searches, find materials through hyperlinks. All that stuff is new, and it's brought on by the digital revolution. So you have materials that are available in multiple copies and a virtually unlimited number of copies. Everyone can look at it at the same time. The finding aids are really fantastic. You can find stuff very quickly. It's all hyperlinked. You can note up cases, find additional stuff. So huge advantages with this digital movement. And it's also healthier for the environment, right? So it's green. It's got that going for it too. The next big move, just like we've seen the first switch from analog to digital, we're now starting to see some of the movement towards computational legal research. And that's really what we're going to focus on today in the context of worker classification. But here, what we see is the ability to leverage the fact that a lot of these materials are available digitally to actually do computational stuff on these materials and actually extract the information to avoid humans from having to go through and read all of the material to reach certain conclusions about those materials and what they may mean for the substance of a client's case or for a research problem that you're looking at. And so using these computational methods to extract meaning and information from large corpuses of materials is something that's really going to be really significant over the next several years as these computational legal research methods come online. And people use different words for these kinds of things. You hear a lot of buzz about artificial intelligence these days, and of course, it's just the very start of AI. And other words you might hear are machine learning. Some people say predictive analytics. All of these things I would lump under this computational movement. in legal research. And my prediction is that 5 years from now, it will be taken for granted that you're using these kinds of tools to get an initial take on a client situation or on a legal research problem. And then the humans are really stepping in and then adding their value on top of, the preliminary computational answer that the new legal research tools are going to be producing. So it's just going to change the way in which individuals conduct legal research. It's going to be a different starting point. Humans are still very much going to be a key player in conducting legal research because we just have different means of going about thinking about these sorts of things than do the machine. So very much about using these tools, being smart legal researchers, and making sure that you're using the latest technology to figure out how to think about new problems as they come up. So this is kind of the big framework, the movement from analog to digital, basically complete. There are still lots of books, but lots of stuff, almost everything you need is available digitally. Next big move is from digital to computational. And we see some of the early inroads being made by software like Tax Foresight on this front. Okay, so under the different frameworks, there are different things that you need to do, but the conventional legal research task is to try to find the like cases. So what are the cases that have come before that are similar to the case that your client's confronting or the research problem that you're confronting? Traditionally, you'd have to go to the law library and try to grab all the volumes that appear to be relevant. In the digital world, you might start with a keyword search to find the relevant cases and then note up some relevant statutory section that you know about or relevant cases that you may know from a textbook or something. In the computational framework, it turns it on its head to some extent. You identify the legal issue that you're researching, and then the system will start interviewing you for your facts. So it's very different. And then on this computational approach, we're going to step through an example this hour. You'll see that you just respond to questions that the system poses to you. So it's going to start figuring out your situation. That's quite different from the traditional ways of doing legal research, where you'd have to read about all the general discussion, the secondary literature, maybe read a whole bunch of cases to try to figure out those insights for yourself. In the computational world, these systems are going to be actually interrogating you, trying to find out what your situation has to offer, and then tailor the response to your particular situation. Instead of projecting your legal imagination into the materials as you used to have to do in an analog or a digital legal research methodology, you will get an answer provided to you and a very brief explanation about why that's the answer. And that's really then a starting point for you to kick off your own research to drill down and find additional cases. But those are going to be suggested by the system. So it's going to be able to identify for you the most relevant and most related cases based on the key essential facts of the system. So you will not be at risk of missing things or overlooking some key case. There won't be, this special moment where a new case is revealed by your opposition you didn't know about. You're going to have all the cases at your fingertips, and you're going to understand the framework within which you're trying to produce legal advice or produce an answer to a legal research problem on your own. So very, very big differences. And this is going to become more concrete as we move through the hour and show you about these computational tools and how you can use them in the context of worker classification. Okay. So what we hear some of the people who've used Tax Foresight so far is that they use it to help figure out how to provide the highest quality advice. They use it to figure out what are the exact questions I should be asking about a situation. What should I be asking my clients? How do I make sure that I'm not overlooking anything? How do I produce the highest quality advice? How do I conduct smarter, more efficient research? And there are a number of testimonials on the slide. I'm sure you're taking a quick read through. People love Case Finder. We've just launched a new thing called Case Analytics that I will show you a little bit about today as well, time permitting. And I should say at this point, actually, if at any time during the webinar you have a question, there is a way to pose questions through the system. At the end of the hour, I will hopefully have some time left to respond to the questions. So as questions occur to you, feel free to use the question and answer function inside the software. I will get to those questions at the end. And if you have them, just don't be afraid, just jot them down, ask them now. And then by the end of the hour, I'll turn and get to your questions and respond to them. So there are a couple other things that users of Tax Foresight are reporting. One thing is that it's really great to quantify the risks for clients. So one of the things that clients always ask tax accountants, tax lawyers, and even within government, when government is considering challenging a tax position, one of the things that they ask is, what are the legal risks? What are the chances that we're actually right here? What are the chances that we're wrong here? In government, the question is, do we want to run the risk of setting an unfortunate precedent here? Do we want to take this case on? Do we think this is a strong enough case that our chances are so good that we want to take this case and actually put a stake in the ground and make sure that we can protect this position? Sometimes the answer is no, this case isn't a strong case, but it's very difficult to quantify just what the likelihood of success is based on reading the existing case law. That's something that algorithms are really, really fantastic at doing. And that's something that Tax Foresight can help users to do. And the same thing applies to lawyers and accountants. One thing that lawyers sometimes ask is, well, should I take this case on a contingency basis? And there, the rationale is, well, maybe I should take it on a contingency basis if I'm sufficiently sure of success in this case that I'm not running a really significant risk here for my client. So the great thing for a client is if a lawyer takes on a case on a contingency basis, then the client doesn't pay anything to the lawyer unless there's success. And then if there is success, then the lawyer gets paid and the client gets whatever's left after the lawyer's fees. If the client loses, then the client's not out any money. And the lawyer actually bears essentially all the costs of the representation. So one of the things that people are using Tax Foresight for figuring out is a case a sufficiently strong case that I want to take it on a contingency? And that's with respect to private lawyers. With respect to government lawyers, the question is this case strong enough to actually proceed confidently to trial? Are we going to win this thing? So in both of those cases, you really want to quantify the risk. In some cases, demonstrate due diligence. So if you're taking a bit of a aggressive position on something, if it's close to 50-50 or maybe even a little bit over the line, you may want to make sure that you're documenting your due diligence in case things get challenged sometime later. And this is mostly the case for accountants, right, who are trying to advise clients on whether or not to take a particular position for tax purposes. Excuse me. Okay, and then the fact is that we're all human, and so we all potentially suffer from this potential problem of confirmation bias, or seeing things through a bit of a distorted lens. So whenever you are representing someone who has a particular interest, there's a risk that you'll be less than fully objective and that you'll start to see things the way that your client wants them to be seen. So a lot of professionals really like the fact that using tools like Tax Foresight can allow them to have an independent double check, an objective check on the way that they're essentially analyzing a situation and make sure that they're not falling prey to a motivated path of reasoning and filtering information in a particular way. So these sort of cognitive biases are well documented, really, really common. Tax Foresight can help professionals produce even better objective advice. Okay, so today we're going to move into this question, and we're going to use the worker classifier on Tax Foresight. But this is one of those old chestnuts of a problem, comes up all the time. The Income Tax Act is really structured in a way to, once you've figured out the answer to this question, there's a very clear regime that applies to a worker if they're an employee on the one hand, or if they're an independent contractor on the other hand. And so all you need to do is take a look at the Income Tax Act and look at its structure, and you'll see that this is a really fundamental question that arises. And in fact, when I teach income tax at the law school at the University of Toronto, this is one of the very first issues that we address, because you need to decide whether you're dealing with, and this is somewhat technical, but subdivision A of division B of part 1 of the Act, or subdivision B of division B of part 1 of the Income Tax Act. So subdivision A runs from sections 5 through 8 of the Income Tax Act and deals with income from office and employment. And if you're dealing with income from office and employment, certain things follow from that. On the one hand, the deductions available to officers and employees are really quite limited compared to the deductions that are available to businesses. And so that's under subdivision B of division B of part 1. And businesses essentially have most of their tax consequences dictated by sections 9 through 37 of the Income Tax Act. And there, the default rule is much more permissive with respect to deductibility under section 9. Section 9 talks about taxing the profit of workers, whereas section 5, that is for employees, talks about salary, wages, and other remuneration, including gratuity. So there's a big difference. Employees basically get, harsher treatment under the Income Tax Act. Independent contractors tend to get more permissive treatment under the Income Tax Act with respect to deductions. Excuse me, got a bit of a cough here. Harsher treatment with respect to deductions for employees. The other difference is employees must have income tax and payroll contributions deducted at source. And so that means the employer has to withhold income tax and also remit employer matching contributions to CPP and EI, for example. So oftentimes hirers also prefer workers to be characterized as independent contractors. And this is just from payroll tax purposes and income tax purposes. This doesn't even get us into any of the Employment Standards Act kind of worker protections that often apply to workers and that others, employers or hirers might want to avoid the application of. And so that's a whole other question about whether for employment standards legislation, whether a worker is an employee or an independent contractor. We're just going to focus on this tax question for now. But with Bill 148 in Ontario being passed, it means that this question is also a very live question in the employment law context. And so in our other software, Employment Foresight, there's some tools that address the employment question. Here, we're just going to be focused on the tax question. Is a worker an employee or an independent contractor for tax purposes? We're going to look at a specific case. We're going to actually drill down into a particular case and look at whether or not on these facts, it's likely that a court would say this worker is an independent contractor or an employee. And so the case we're going to look at is a case called Sear. And it was decided by the Tax Court of Canada last year in 2017. Okay, so Sear is a case involving a music school. And the music school was operated by Ms. Sear. And essentially, the music school took the position that the instructors of the music school were delivering lessons on behalf of the music school as independent contractors. So what this means in concrete terms for the music school is that the music school essentially just calculated, added up how many lessons each music teacher delivered on behalf of the school, and then paid the instructor for the lessons that they paid or that they taught. And so they were paid for the lessons that they taught, and that was it. So they weren't on payroll. There weren't payroll taxes imposed. There was not income tax deducted at source. And all the lessons were delivered by these instructors. The agreements that the music school had with the teachers were a little bit ambiguous. So in the past, there was the position taken apparently that the teachers were employment, but then it became clear that it would be a simplified administrative process to just treat them as independent contractors. And so the music school attempted to do that. So the CRA objected to the treatment of the music teachers as independent contractors and said, no. These music teachers really need to be treated as employees of the music school. So let's drill down a little bit into the arrangements. the teachers performed their duties during the business hours of the music school. They followed a schedule and a lesson plan established by the music school using instruments that mostly belonged to the music school, and the students attended at the music school premises. The teachers did find sheet music and other things for their classes using their own personal computers, but there wasn't any indication that the teachers had purchased these computers for business purposes. So these are typically personal computers that the teachers were using that were basically on an ad hoc basis used to find sheet music to assist them in their teaching at the music school. The teachers had to adhere to a strict dress code. They were paid an hourly rate by the school based on the teacher's experience, their seniority, their level of musical education. The workers didn't have to invoice the school in order to be paid. They were simply paid by the music school. The music school obviously kept track of the lessons that they were teaching and just added them up and calculated how much they were owed and would pay them proactively. The workers didn't incur expenses from their teaching, and they weren't allowed to exchange contact information with their clients. You can understand why that would be really important in the context of a music school, because from the music school's perspective, they wanted to remain in between as the middle person between the students and the instructors. So you wouldn't want, as a music school, to have your students and their instructors setting up side arrangements for the instructor to go deliver additional lessons at the home of the students, for example. And so that was very clear that they were prohibited from delivering lessons through that way with students of the music school. The teachers also had limited ability to increase the revenues that they were generating from teaching lessons. They could teach more lessons at the school, but they weren't really allowed to go beyond that and teach other lessons. As a practical matter, little teaching was done by the teachers in other places. All the management decisions were made by the music school. Apparently, they were allowed to teach master classes to really sophisticated students and earn a little bit of a higher rate of income, but the opportunity for these teachers to increase profits is pretty limited. And so the question for us, as it was for the Tax Court of Canada in this case, is, are the music teachers likely to be characterized as employees or as independent contractors? And so what we're going to do now is jump into Tax Foresight and analyze this particular set of facts. So I've logged in to Tax Foresight. You should see on your screen the landing screen for me. I've got my favorites pinned at the top here. Worker classification is the one we're going to be looking at. I've also got residency, gross negligence, and GAR here. And what we're going to focus on here is using the classifier functionality as a first cut to figure out whether these music teachers should be treated as employees or independent contractors based on all the cases that have been decided in the past on this particular issue. So with respect to worker classification, there are hundreds and hundreds of these cases that have been decided. I'm going to click on the classifier here. This explains that if a worker is an officer is automatically deemed to be an employee pursuant to subsection 248 of the Income Tax Act. It's just simply defined. An officer is deemed to be an employee, so it's a matter of definition. But for our music teachers here, they are not officers of the music school, so that doesn't apply here. So we can go ahead and confidently click next. Okay, so what you'll see here is just a few things to notice. Here reminds us that we're on the worker classifier. There are going to be 17 questions that we need to answer, and we're already able to see that we're going to be stepped through essentially 5 different classes of questions before we get our result. Okay, so what is the worker's profession or occupation? Well, the worker here is a music teacher, so I'm going to type that in. How would I describe the hirer's business or activity? So the hirer here is the music school. So I'm going to describe it as a music school. At the time of contracting, how did the parties intend to characterize the relationship? Well, the music school and the music teacher are taking the position that this is an independent contractor relationship. So I'm going to say independent contractor here. And as I mentioned, at introduction of the whole issue around worker classification, that's often in the joint interest of both the workers and the hirers to get treated as independent contractors, because there's more permissive deductions available to independent contractors, and you can sidestep payroll taxes, and you don't have withholding at source. So it's a much more flexible arrangement. For the same reasons, typically the minister and the government is much more skeptical about claims that workers should be treated as independent contractors, because it's just it's often quite a self-serving characterization. So here, the teachers are alleging, and the music school is alleging, that they are independent contractors. We'll just select an arbitrary period here. There are a number of teachers, but let's just say 12 months for an average instructor teaching at the music school. Okay, and if we have any uncertainty about any of these questions anytime, we can just hover over this little tooltip and it'll provide a little bit of explanation about how to answer these questions. Okay, so next. Okay, so are the music teachers monitored or supervised by the hirer? Yes, absolutely. All those lessons are delivered at the music school's premises. Who determines what work is to be done by the worker? Well, the hirer does, because the music school essentially tees up the lessons and the music teachers come and deliver those lessons. Does the worker have the freedom to turn down work from the hirer? Yeah, I would say yes. If a music teacher didn't want to teach a particular student, they could say, no, I'd prefer not to teach that particular student any longer. Does the worker set his or her own hours and schedule? Yes, within reason. So within the business hours of the school. So this is a little bit debatable. I think what we'll do is we'll flag this one, number 2.4, and come back to it. We'll say yes, the worker does set his or her own hours and schedule, but we'll come back and say no, because those hours and schedules can only be set consistently with the business hours of the school. Does the worker have the freedom to determine how the work should be done? Yeah, so they're hired for their expertise in instructing students, and they are given some leeway to determine how those lessons should be delivered. Number 2.6 is also something that we'll come back to. So this is the worker free to work for other people or companies? I think technically, yes, but as a practical matter, they don't really work for other people or companies, and they're not really free totally to work for other people or companies, because they're prohibited from exchanging contact information with their students. So they can't just willy-nilly work for the students outside of the context of the music school. So we're going to say no for now to this question. We can circle back to 2.4 and also 2.6, change those answers and see how it actually affects the overall result. Can the worker delegate or subcontract work without notifying the hirer? No. So in some circumstances, if a teacher fell ill, for example, they might be able to get someone else to sub in for them, but they would certainly have to tell the hirer, and it wasn't a usual practice. It wasn't that they were completely free to nominate anyone and send anyone, and especially without notification. So I'm going to answer no to 2.7. And does the hirer impose a dress code or require the worker to wear a uniform? Yes, absolutely. We're told that on the facts, so I'll say yes. Okay, who owns the most important tools that the worker uses while performing services? Well, here it's the case that the hirer uses them. The hirer provides the most important tools. So the hirer provides the venue in which these lessons are taking place, also provides most of the instruments. It is true that some of the teachers have their own instruments, but the hirer really is providing most of the tools for this. We can come back and change any of the questions. I think this one's pretty clear, though, that most of the key tools belong to the music school. Okay, other than the loss of work, is the worker personally at risk for loss? Here the answer is no, not really. If they work an hour, it triggers a fixed payment of an hour's worth of music lessons. It's really difficult to imagine a circumstance in which they're at a risk for loss. They're not bearing the risk of marketing the school. They don't have the fixed cost of the premises. They're really billing their time. And so as they spend time, they're going to get paid for their time. They can't really generate a loss. And they're not reimbursed for work-related travel expenses. Okay, where are they doing most of their work? Most of their work's being done in the hirer's workplace. Did the hirer provide the worker with training? No, not really. These are all instructors who have musical training. and know how to teach music lessons. So that you can see that we've reached the end of the questions here. What we've done in building this questionnaire is kind of reverse engineered all of the things that courts look to in identifying whether to characterize a worker as an independent contractor or as an employee. So these are the kinds of factual questions that courts key their decisions off when they're making these kinds of judgments. So we trained our algorithm on hundreds of cases on this, and we've identified these 17 questions as being the really key questions that courts look to in deciding on the characterization. So what you'll see when I click on compute is that it's going to take all of these responses, compare all of these responses to all the previously decided cases on this topic, and make a prediction about whether a court would hold that this particular worker is, so remember, we're taking this worker who's got 12 months of experience working for this particular music school and say whether this worker is better characterized as an employee or as an independent contractor. Then we can go back, we'll switch the answers to questions 2.4, 2.6, see how that influences the result. Before I click compute, I'm going to invite you as a listener and a watcher of this webinar to do your own mental analysis. So if you had to identify which way you think the needle should be pointing here in terms of employee or independent contractor, which way would you say you're leaning in characterizing this case? And so this is really intuitive. It's based on what you know about the real world, based on what you know about how courts decide these cases. Maybe you've read a lot of these cases, maybe you haven't read any, maybe you have a common sense appreciation of how worker classification works. But I'm going to invite you to, in your own mind, come up with a specific number. Think of the percent chance that you think that this worker is going to be characterized as, I'm going to say, well, one way or the other. So either say independent contractor, X percent, or employee, Y percent, whatever it is in your own mind. And let's just see how well calibrated your prediction is to what the courts are going to do most likely in this kind of situation. Okay, ready? Okay, assume you've got your answer. I've got mine. Okay, so it looks like, based on the existing case law, a court would say these workers are close to the line, but they're tipping over into employee territory. Okay, so we got the answer here, the prediction. We've got this confidence, 63%. So what's interesting is that this is a really close case. So the algorithm saying this case is very close. It explains, based on the various criteria, how it's likely a court would be thinking about the different elements of the worker classification test here. So control is really important. And it looks like that is one of the decisive things here, tipping this into an employee characterization. We'll see that a number of the most similar cases are identified here. So a lot of the most similar cases are coming out as independent contractors. Some are coming out as employees. So if we hover over the similarity bar, we can see that this employee case shows that we've got a bunch of different aspects of that case that are very similar to the facts of our case. Some dissimilar factors are about who sets the hours and schedule and the requirements to wear a uniform. So we can go back and change some of those answers, see how it influences the result. We've got this Wenzel case, a different set of similar factors, some that are dissimilar. So you can really see that it is a very close case, right? It's true, we have only 2 employee cases among the top 10 most similar cases, 8 independent contractor cases among these top 10. But what's interesting is the algorithm's actually super smart because it's going the other way. It's picking up on different things. One of the things that might be driving this is a time trend. So if it's the case that some of these cases are earlier and they're more recent cases indicating a trend more towards employee, that would be one thing. It could be that there are a whole bunch of cases just beyond these 10 most similar that go employee, and so it's hard to say. But surely there's something here suggesting kind of case. So, all right, so those are the similar cases. And we've got these references. So these are the kind of the most high profile cases among all the cases that have been decided. These are typically appellate cases like Weep Doors, a federal court of appeal case, Sagaz Industries, Supreme Court of Canada case on worker classification. We've got a Privy Council case here from 1946. So lots of old chestnuts here. Okay, I did say we should go back and change a couple of the answers and see just how sensitive the analysis is here to the overall answers here. So does the worker set his or her own hours and schedule? So I'm going to say no to this and see how it changes the result. And the reason to say no would be, well, the teachers can only teach classes during the ordinary hours of the music school. So if it's outside the ordinary business hours of the music school, then the worker can't set his or her own hours and schedule. So I'm going to say no to that and recompute. Okay, so that's a very, very, wow. Okay, so that ability to set own hours and schedule is a very important finding of fact. So if I were arguing this case for the government, I would want to make the argument that, look, the hours, so what I'd be looking for is this kind of argument. I'd be saying, okay, the hours of the music school, and I don't know if this is true, but I would just be thinking about this from an advocacy perspective. What I'd be saying is, okay, the hours of the music school are such that there's a very limited window in which teachers have the option to set their own schedule. And it's very likely with music schools that the lessons are going to be offered in the evenings and on weekends. And so those are the only times those are the only windows within which the music teachers can set their own schedule. And so that's not complete freedom to set their own schedule. They can't offer lessons during the day, for example. And the reason being most school-age children are in school during the day. And so it doesn't make sense to offer music lessons during the day. And so I'd want to characterize it as, no, the teachers don't have the freedom to set their own hours and schedule for music classes. On the other hand, if I was arguing this for the taxpayer, I'd say, well, that is actually all the freedom because that's when the clients want to take the lesson. So you can only have chances to set your own hours and schedule within the constraints imposed by the ultimate client, and the ultimate client here are the students. And so de facto, there is that freedom to set the hours and schedule. So that would actually be a key factual determination. Note though that it doesn't flip the result, right? So we've still got the best answer either way is that it's an employee characterization. It just makes it much closer to the line if you can actually convince an adjudicator that the teachers really do set their own hours and schedule. So I'm going to flip this back 2.4 and say, yes, they do have the ability to set their own hours and schedule. And I'm going to look at 2.6. So is the worker free to work for other people or companies? Remember, as a practical matter, I said, no, not really, and because they don't really do it. They're not free to exchange information with their clients. Let's say there was a relaxation of this requirement and the music school said, yeah, you can work for other people or companies. You can teach lessons outside of the music school, all that you'd like. What's your intuition? Well, my intuition on this is that this should make this very clearly, maybe not very clearly, but more clearly into an independent contractor kind of relationship. If the worker really is truly free to offer lessons outside of this context. Okay, so I'm going to click. Okay, so I'm going to click recompute here. I've changed this to yes, the worker is free to work for other people or companies. I'm going to click recompute. And yes, it does indeed flip the result to independent contractor. Now, of course, this wouldn't really work for the music school because you don't want people to work for their students outside of the context of the music school. It doesn't really work for the music school at all to allow that to happen, because then students would come, they'd find a teacher that they really, really like to deliver those lessons, and the teacher would then go and deliver lessons to the students inside their home or something. And so it would lead to the music school being out of business, losing clients to instructors very, very quickly. And so that wouldn't really work. So I don't think that's really a sustainable answer here. So I'm going to stick to no here. Okay. And then we should get the same answer, employee 63%. Okay, so a couple things I want to show you here. One is you can download a report of this classification. So I click the download PDF and I get the report. So the report is something that I can file with the information relating to this taxpayer, put it into the file. If I'm taking the filing position that these are independent contractors, I might still say, yeah, you know what? For tax purposes, I'm going to take the position as your accountant that you should treat these you could treat these teachers music school as independent contractors. It's pretty close to the line. I don't know, 63%. It's one of those things. It's a very close case. I'm going to give you the benefit of the doubt here. We're going to take the filing position that these are independent contractors, but it is very close. I think all things considered, we could say that they kind of are tipping right on that boundary. I think we can take as a filing position that they're independent contractors, but knowing that if it is challenged, if it does go all the way to court, probably the better answer is that they're employees, or it may be the better answer that they're employees. That could be something that you could do. I myself would probably be more risk averse and say, well, depending on how we answer that question around setting hours and schedule, it's either 63% or very, very clear that those workers are employees. So I might be a little bit more risk averse and say, I'm not going to take that as a filing position. That doesn't work for me in terms of giving that advice. But different professionals have different appetites for risk. Some might say, yeah, that's actually okay, and take that as a filing position. So you can download that report. You can share it with different people. So I might just send myself this result and say, here it is, Ben. And so when I click the share button, I'm going to receive an email with that PDF attached, and I'll get that report that I can look to and maybe file it for my client. I can save this for future reference and say music school. Not going to save any personally identifying information here, just call it music school. At any point, I can go back and change any of the answers. Okay. Excuse me. Okay, what else can I do? Well, I might want to find more cases. And so this is where Case Finder comes in really handy. Here, basically, what I see is that I've identified all the cases that are most similar to the facts of the case as we've entered it into the system. I can hover over here and see that the most similar cases share all but two of the factors with our case. If I click on any of these links, it'll take me out to TaxNet Pro, and I can continue on my research there in TaxNet Pro. I might say, you know what, I only want to find cases that have gone to the tax court, and I only want to find cases from 2015 to 2018. And so I can drill down and restrict the ambit of the search fairly significantly here. So this is going to be turning up all the most similar cases to my case. If I want to put additional emphasis on certain aspects, I can say it's really, really important. For example, I'm going to clear this one by year. I only want to find Supreme Court of Canada cases, so I can dial up the relevance of that, and you'll see then the Supreme Court of Canada cases are coming up much more to the top here. But you'll see that the non-match factors here are fairly significant, so I can dial that off. I can turn this on and off and just see the cases. Now, one of the things that's new, well, before I get to case analytics, maybe what I'll do is I'll say, okay, I really want to find the cases where the result was independent contractor. So I'm going to dial up the relevance of independent contractor, and maybe I'll take off some of the things. So I wasn't really sure about the hours and schedule thing, and I wasn't as sure about, let's see, working for others. Let's see. Okay, turn off delegation, turn off how work is to be done. Okay, let's see. Okay, cool. All right, so what you can see, and I think it's I think it's pretty intuitive. You just click on the different elements. It's going to bring up the cases that are most related to the different criteria that we're looking at. And it's a way to find those cases very, very quickly. So the suggestion is, based on how I filled this out, that this Teach and Embrace Corp case is the most relevant case. I can go into TaxNet Pro, log in here, and it should take me directly to that particular case. And I can see at a glance, okay, it's this case. It's about a tutoring company. Okay, this is very, very similar to the case that we're looking at. It's Archambault. It looks like it's a case out of Quebec, so that's interesting. That's one of the things that you can change here. Is I really want to find cases by province with at least some of the classifiers. I don't know that we have it here. I can go into case analytics. Maybe what I'll do is just clear all of these results. Okay. Now I can maybe show this more clearly. Find cases by intended characterization. Find cases by supervision. So worker is monitored or supervised by the hirer, and it's clear that the hirer determines what work is to be done. Okay, and then let's say the worker does have the freedom to turn down work from the hirer. If I just know those three things for sure about the case, you might say, well, I just want to know what the likelihood is that if those three things were true, that this is going to be an independent contractor or employee. So one way to answer that question might just be to intuitively look at this list of the top 20 cases and say, okay, 1 independent contractor, 2, 3, 4, 5. 5 of the top 20 cases are independent contractor. That must mean 15 are employees. So that's like 3/4 of them are employees. Another way to answer this question is to go into case analytics. And so this is interesting because now it's saying, okay, there are 31 cases that match on all 3 of these aspects, decided by the courts in the tax context between 1997 and the present. So in the last 21 years, there are 31 cases that found the workers monitored or supervised by the hirer. The hirer determines what work is to be done, and the worker has the freedom to turn down work from the hirer. And in those cases, it looks like the courts tend to find that those workers are employees 71% of the time. What if the worker doesn't have the freedom to turn down work? Okay, wow. So the worker's monitored or supervised, and the hirer determines what work is to be done, and the worker doesn't have the freedom to turn down work. That makes it almost, a huge slam dunk that this worker is going to be characterized as an employee. So this is really, really powerful. It gives you a sense just how sensitive the results are. So this is a really powerful one. You want to be able to say, if you're arguing this from the worker's perspective, that the worker does have the freedom to turn down work from the hirer. What about this aspect? Does the worker determine, wow. So if the worker determines what work is to be done, it looks like that's very powerful in favor of the worker. There are only 4 cases that match on that context, on these particular facts, but if the hirer determines what work is to be done, it really does swing it the other way. If they jointly determine it, what happens? Oh, there's only 1 case, so that's not really particularly helpful. Okay, so let's say in most of these cases, it is going to be the hirer determining what work is to be done. What if the worker's not supervised? What influence does that have? Wow, okay, so it makes it very powerful that it's likely to be an independent contractor. So most of these cases do involve monitoring or supervision by the hirer. So at a glance, we just get a sense of this. I'm going to change this back now because I find this a very fascinating result. I want to know about these 2 cases. What happened in these cases? Here we have a lot of the control in the hands of the hirer, who's monitoring and supervising the worker, determines what work is to be done, and doesn't give the worker the freedom to turn down work. Let's click on that. Do I want to show these cases? Yeah, I do. What are those cases? Okay. So Royal Winnipeg Ballet and Burwell. This means that these cases are likely to be outliers. Very interesting. Royal Winnipeg Ballet. This is a case that lots of tax lawyers are fond of citing in the context of worker classification. And the reason is that Royal Winnipeg Ballet exerted a lot of control over those dancers, and yet the court still held that they were independent contractors. But this is an outlier of a case. We can go back to case analytics, right? this is how big of an outlier that case is. Let's see. We'll clear this. So it's that big of a, because we have supervision, we have the hire determining what work is to be done, and we have the worker not having the freedom. So it's like a 2% outlier. 98% of the cases matching on those features would go the other way. That would make me really reluctant to rely on Royal Winnipeg Ballet to justify my case if I were going to court. And so I just flagged that here. That's an interesting artifact of this analysis coming out of case analytics. So you can see just from this quick poking around in here, Case Finder helps you find cases. Case analytics can help you identify outlier cases, maybe identify novel arguments. So I might go into Royal Winnipeg Ballet and say, okay, so what was it that really convinced the court in those circumstances to reach an outcome that seems not to lie with the great bulk of the case law in this area? Okay, so maybe what I'll do is just come back here to the results screen and talk very quickly. You can see we've got a whole bunch of different functionality in here, GAR, a whole bunch of income versus capital functionality with classifiers, case finders, case analytics, different things relating to different sources of income, inclusions, taxable benefits, shareholder benefits, home office, CCA, CCPC status, interest deductibility, residency, carrying on business, all these jurisdictional classifiers, stuff relating to different kinds of penalties, some election navigators. So these navigators are more rules-based things that we can step through. We've got some webinars planned in the future around navigators we can talk about, and then some stuff in indirect tax. So a question that comes up all the time in GST, HST context is something a single supply versus a multiple supply for the purposes of figuring out what rates of input tax credits, for example, should apply on different kinds of supplies. So lots of stuff on Tax Foresight, more to come in the future. Okay, so I'm just going to swing back here. And essentially, what we learned is that employee would be typically the better characterization. That's in fact what the court found in SEER. So based on how we answered the questions and the worker classifier, it came out as employee rather than independent contractor. I think what I'll do now is take any questions that people may have. Let me just log in here and check out whether there are any questions that people may have. We've got about 5 questions left, 5 minutes left for questions now at the end of the hour, and I'm happy to answer any questions people may have about either about worker classification in general or this in particular. Okay, so let's see. All right, let's just get back into this. I'll give you a chance to type in your questions. All right, I've got a question here. Yeah, so one of the questions that we've got here is, what are you working on right now? What's next for Blue Jay Legal? Can you tell us more about your structure, how many lawyers you employ, and so on? Yeah, sure. So we're very, very busy working on new functionality for Tax Foresight. So the next things in our list are certain functionalities related to GST and HST. So one of the big questions that we've just introduced functionality for is that single versus multiple supply question that I just finished talking about. Relatedly, and that just launched this past week, the next functionality that we are working on relates to whether something's an exempt financial service for the purposes of being exempt from GST and HST for tax purposes. So financial services are exempt usually from VAT system. So that's a big question, gets litigated a lot, because if you're able to say that something is in fact an exempt financial service, then of course there's no GST and HST that applies. So that's really helpful in that context. We also have a list of other classifiers that we're working on. So we're adding stuff all the time to Tax Foresight, and we just added the interest deductibility functionality as well. Case analytics is just new, so the vision is to really expand Tax Foresight out and include a whole bunch of additional functionality over the coming months. We have the company has 21 full-time employees at the moment. We've got the legal research team that constitutes more than half the company, and these are lawyers from big law firms who are now working with us full-time, conducting the legal research to support the development of these tools using AI and machine learning, and working closely with data scientists to produce the analysis. Somebody has asked, how much is the software? So the software is being offered on a subscription basis by Thomson Reuters. So Thomson Reuters is responsible for selling the software. And the cost of the subscription really depends on the size of the organization that you're working with. It is being offered for procurement through the federal government. So if you happen to be an employee of the federal government, you can find it on the NMSO service. So you can sign up really easily through federal procurement that way. If you're in the private sector, the best way to get in touch with us is to send us an email or connect with us with one of our lawyers. The details are on the screen, but it's offered on a subscription basis. It's priced like another, conventional legal research service. It's all you can eat. You sign up and you pay an annual fee in advance, and then you can use it as much as you'd like in your practice. Okay, other questions? How much is the software? I've answered that. How up to date is the product? So the cases get added. Our ambition is to add cases to the product within 2 weeks of them being released by the courts. So ideally, we're never more than 2 weeks out of date, and about half the time will be within a week of when the cases have been decided. So we do batch updates regularly. And one interesting thing is when you're looking at the classifiers, the answers don't really depend that much on the very latest cases. Of course, we are updating it, and it's important that we include all the latest cases, especially for the case finder. But when you're talking about hundreds and hundreds of cases that have been decided, the last 1 or 2 cases don't change the analysis very much when they're released. They're, of course, important to know about, and that's why we keep the product so up to date. But they don't usually dramatically upend all the previous case law. I'd be really worried about the rule of law if that were true, that they actually really dramatically changed the outcome. So we're at the hour. I'm respectful of people's time. And so thank you very much for joining us on this Tax Foresight webinar. And I hope to see you again sometime in the future. And thanks for using Tax Foresight, and thanks for your attention today. Take care.